Welcome once again to Lehto's Law. Here's Steve Lehto.
I got an email from a viewer, and this one is not as concise as the last time I did a video based on an email from a viewer, but the story needs to be told, and the question needs to be asked. So, my husband and I enjoy watching your videos on YouTube. We have a question we thought your viewers might also be interested in knowing more about. There's always been a bus stop in front of our house, which was great when our son was small. This current school year, one of the families that is on this stop has several kids, but their house is several blocks away if they use the roads. So instead, they walk through our second lot, which is just open grass and backs up to their backyard. No one in their family has ever asked permission to walk across our private property every day. We have two potential issues. One is, if someone gets hurt back there, would we be liable? And two, would that answer change if they had asked and we'd given them permission? We've only been aware of this for a couple months, and we're unsure about whether we should say anything or do something like put up no trespassing signs. We don't want to be unfriendly neighbors, but we also don't want to get sued. The oldest child texts the entire time she is walking. I'm shocked she hasn't tripped yet, at least as far as I've seen. Thanks. So we're going to talk about trespassing. And I've had situations similar to this at various places I've lived, and I've known many people who have. And the issue is you own a piece of property. It's yours. You own the piece of property. And the rights that come along with ownership is the right to exclude people from your property. You can tell people, get off my property. And I've done that before. Usually somebody on my front porch trying to sell me something or to change my religious views. But the point is, it is your property. Theoretically, you have the right to tell people to stay off your property. I say theoretically because in a practical setting, it often gets to the point where, do you really go over and say, excuse me, your children can't walk through my yard, I'm going to make them walk around the block. And then you become the bad person. So what I'm going to tell you about here is a couple things. First of all, the laws regarding trespassing will vary from state to state. And you might say, but Steve, trespassing is obvious. Someone's on your property, they're trespassing. Well, the real question becomes, what can you do if someone is trespassing, and what is necessary to put them on notice of the nature of the private property? So, for example, the question as to how these houses are laid out, I don't quite know. But would it be obvious to the parents of the children who are cutting through that property who owns that piece of property? They might just think it's a quote-unquote vacant lot. They might not know you own it. The second question, of course, though, is if you were to go over and talk to them, do you really want to say, by the way, your kids can't cut through that yard because we're scared they're going to fall over and get hurt and sue us, and then suddenly you become the mean neighbors? Okay? But that's really what it boils down to. Because, yes, you do have the right to tell people to stay off your property. But will it make good neighbors out of people? Probably not. So I'm going to talk about what the actual statutes say, and the examples I'm giving to you are from Michigan. Many states have got parallel statutes to this, and I would suggest you do the same search I did, but just substitute the word Michigan for whatever state you're in. So Ohio, trespassing laws. New Jersey, trespassing laws. Because in Michigan, what you get is two sets of laws. You get the criminal laws, that is the stuff you can get arrested for. And you've got the civil stuff for which you can sue somebody who trespasses on your property. So we'll start with the criminal at MCL 750.552, which is part of the Michigan Criminal Code. MCL's Michigan Compiled Laws, the blue book's behind me. MCL 750.552, trespass upon lands or premises of another, exception, violation, penalty, etc. A person shall not do any of the following: enter the lands or premises of another without lawful authority after having been forbidden to do so by the owner or the occupant or the agent. So a person, theoretically, in Michigan can walk onto land until they've been told they can't. However, you have to understand that if it's posted, that's another story, but we'll get there. You cannot remain without lawful authority on the land or premises of another after being notified to depart. So if you walk up to somebody and say, excuse me, you're on my land, get off. If they don't get off the property at that point, they're trespassing. They cannot enter or remain without lawful authority on fenced or posted farm property of another person without the consent of the owner or his or her lessee or agent. A request to leave the premises is not a necessary element for violation of the subdivision. This subdivision does not apply to a person who is in the process of attempting by most direct route to contact the owner to request consent, and it also does not apply to a process server attempting to serve somebody on that property. So it does say that you cannot enter or remain on fenced or posted farm property. So the real question there becomes, what happens if you are entering property that's not farm property, but is posted or fenced? It appears to be a poorly written statute in that sense. So theoretically, in Michigan, if you were walking across a piece of property that is not farm property, it's not fenced, not posted, it's just a piece of property, someone's got to tell you to get off of it. If it's fenced or posted, no trespassing, then you're in trouble if it's farm property. If it's not farm property, this criminal statute might not apply. And I'm sure there's probably been case law on this, but it's oddly written, because it seems strange to me that if I own a big piece of property and I put no trespassing signs around it, and people go on and say, oh, I wasn't paying attention, because it's not farm property, I can't do anything about it. Well, that's the criminal statute. The criminal statute. I mentioned before, and I've mentioned before also, there are a lot of things for which you can be arrested and sued. So if you steal money from somebody, they can call the police and go, hey, this person stole from me. They can also sue you to get their money back. And sometimes both things can happen to you. So here's the civil aspect regarding trespassing. Entering or remaining on property of another at MCL 324, 73102. So this is not part of the criminal code. This is totally separate. A person shall not enter or remain upon the property of another person, other than farm property or wooded area connected to farm property, to engage in any recreational activity or trapping on that property without the consent of the owner or his or her lessee or agent if either of the following circumstances apply. The property is fenced or enclosed. The property is posted in a conspicuous manner against entry. So you'll notice going back it says a person shall not enter or remain upon the property of another person other than farm property. So remember, farm property is covered by the other statute making it criminal. But here, they're simply saying if it's posted or fenced to exclude, then you're violating the statute. MCL 324 73102. It's very unusual to have a .73102, 5 digits after the decimal. I know it's not a decimal in that sense, but you know what I'm saying. So a person shall not enter or remain upon the property of another person to engage in any recreational activity or trapping on that property without the consent of the owner or his or her lessee or agent. I guess you could argue about what's meant by to engage in recreational activity. But I would argue and say that simply if you're going for a walk and you're walking on my property, sounds recreational to me. So you can't do that if the property is fenced or enclosed and is maintained in such a manner as to exclude intruders, or the property is posted in a conspicuous manner. And they define it here. The minimum letter height on the posting sign shall be 1 inch. Each posting sign shall be not less than 50 square inches. And the signs shall be placed to enable a person to observe not less than one sign at any point of entry upon the property. And what they're getting at there is if you have an obvious entryway to your property, let's suppose your property has frontage on a road and it goes way, way back here. If you have a bunch of no trespassing signs across the front and somebody wanders on in the back, they go, I didn't see any signs. So you got to put signs everywhere so the person can't make that argument. Explain to me how you got out there and didn't see any of those signs when there's 12 of them out there and they go all the way around, okay? Meanwhile, a person shall not enter or remain upon farm property or a wooded area connected to farm property for any recreational activity or trapping without the consent of the owner or his or her lessee or agent, whether or not the farm property or wooded area connected to the farm is fenced, enclosed, or posted. So farm property actually gets a slightly better level of protection. Doesn't need to be posted if it's obviously farm property. Now, one of the questions that several people asked me about a while back, I talked about whether or not you can walk through a river on someone else's property and so on. There actually is a exception here for rivers. On fenced or posted property or farm property, a fisherman wading or floating navigable public stream may, without consent, enter upon the property within the clearly defined banks of the stream, or, without damaging farm products, walk a route as closely proximate to the clearly defined bank as possible when necessary to avoid a natural or artificial hazard or obstruction, including but not limited to a dam, a deep hole, a fence, or other exercise of ownership by the riparian owner. But keep in mind that that has to be a navigable public stream, and it has to have clearly defined banks. And in those cases, you can step out, go around an obstacle, and get back in. Meanwhile, if your hunting dog gets loose on someone else's property, you can go in and retrieve it, but you can't bring your gun. I kid you not. A person other than one possessing a firearm may, unless previously prohibited in writing or orally by the property owner, enter on foot upon the property of another for the sole purpose of retrieving a hunting dog. Now, you might say, but wait a second, Steve, why would they say this bit about not in possession? The obvious reason. Because if I find a guy on my property and he's got his hunting dog and he's got his rifle, and I go, what are you doing on my property? You're not allowed to be here. And he goes, oh, I was just fetching my hunting dog. Then why do you have this? Oh, what do you want me to do with it? Well, the law says you can't bring that on the property to get your dog. So if your dog legitimately ran away and you got to go fetch it, you put that down and give it to somebody else or do something, but it cannot be with you. Otherwise, it looks like you're hunting and trying to pull a fast one by saying, oh, I was just going to get my hunting dog. And you should also know that several of these say that you cannot enter the property or trap on the property, because unfortunately what happens sometimes is there are people out there who still trap animals and they will put traps on other people's property. And I know this because I've had clients who called me and said, Steve, I found traps on my property. My dog almost stepped in a trap. I walk over, my dog sniffing something, I look over, it's a leg hold trap. And under state law, they're required to put a name and an address and a phone number on the trap to indicate who owns the trap. Sometimes they do, sometimes they don't. But the point is that if you enter onto my property and leave a trap and then get off the property, you've been trespassing. And the presence of your trap will prove that if you followed the law. If you didn't follow that, you just lost a trap. So I don't have much sympathy for guys who lose their traps in that manner. So I could tell stories. It's going to be a long video otherwise, so I'll tell another story at a later day. Sorry. Getting back to the woman who contacted me, and I do not know what state she's in. But at its simplest, her and her husband own a piece of property. They got a piece of property adjacent to theirs, which is vacant. Another neighbor's kids cut across that property to get to the school bus. Well, yes, you could, if you wanted to, most likely exclude those kids by putting up no trespassing signs and talking to the parents and saying they are not allowed to cross our property. Problem, of course, is you become the neighborhood jerk who doesn't let kids walk on your grass. So if you go and talk to them and say, hey, look, we're just a little concerned about liability, that won't make much of a difference, but you are absolutely correct. Let's suppose a kid is walking across your property one day and sticks their foot in a gopher hole, and they go down and their ankle snaps and they got an injury. Are you going to get sued? Probably. Will you win the lawsuit? Quite possibly. It's hard to say. But, you know, the question is how much sympathy does a jury have for a little kid with a broken ankle? Or what does the insurance company think about all this? And so it's a tough question. It's a really tough question. And these kinds of things happen in neighborhoods all across America. And if you go and talk to them, does it make you any more liable or any less liable? Probably not. Because if you talk to them and say, hey, look, your kids have got to be careful in that yard, then something does happen, you know, they're probably going to say, gee, they came over and warned us. I just didn't know. They said that we shouldn't walk the yard, but we didn't know about those gopher holes. They didn't tell us about the gopher holes. And so there are rules about what you can sue somebody for when you're on their property. And if you are technically a trespasser, that is, you're walking across property without permission, and you know you shouldn't do that, then the duty that's owed to you is very low, but there's still a duty nonetheless. But if it's somebody who's walking across the property and they think they're allowed to be there, then the duty is even higher. So I know that most people faced with this would simply chalk this up to there's not much you can do about it and move on with your life. But if you wanted to, you could post signs, most likely, and then go talk to the parents and say, your kids can't cut through our yard. We're worried about liability. And again, like I said, you'll become the mean people in the neighborhood. So there you go. But the interesting thing to remember here is that in many states, there's a criminal aspect to trespass and a civil aspect, which means if someone's trespassing on your property, you can call the police and say, I want that person arrested or ticketed or whatever it's going to be in your jurisdiction. And if you find out who they are and you want to, you can sue them. Because I actually realize now I forgot to read you the last paragraph. And this is the fun part. MCL 324-73109, violation. The owner of property on which a violation of this part is committed may bring a cause of action against an individual who violates it for $750 or actual property damages, whichever is greater, and actual and reasonable attorney fees. So let's suppose you own a piece of property. You post it. You're in Michigan. There's signs all around saying no trespassing. You catch somebody on the property and you identify them. If you want to, you can sue them for $750 plus attorney fees and court costs just for setting foot on your property. If you want to. Now, will the court enjoy that lawsuit and be glad you brought it? Maybe not. But if that's what you got to do to teach somebody a lesson to keep them off your property, maybe you do it. If they do it more than once, I would suspect you can make the argument that each time they do it, it's $750 a pop, plus attorney fees and court costs. So you can be arrested and charged with a criminal offense of trespassing. You can be sued for trespassing. The question is, do you want to sue the family whose little kids cut through your yard to get to the school bus? That's a bigger question, and that's more of a question of like neighbor etiquette than anything else. But that's the best I can tell you. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. A man is also known by the company he dodges.